My name is John Brittain. I have the pleasure of interviewing Martha Stone. Today is April the 12th, 2012. I am conducting this interview as part of the Connecticut Bar Foundation James W. Cooper Fellows Oral History of Connecticut Women in the Legal Profession Project. This project is sponsored by the Connecticut Bar Foundation. Please tell me your full name.
Martha Stone.
And I hate to ask you this question, but what is your birth date?
11/9/48.
Who were your parents and what did they do?
My parents were Al and Lillian Stone. My father actually had graduated from law school, and then it was World War II, and he went into the service, and when he came back, he didn't practice, and he went into the business of his father, and at that time, it was the antique business.
All these years I've known you, Martha, I never knew your dad was a lawyer, too. I knew he was a business person. And do you have any siblings?
I had a sibling. I had a sister who was 4 years younger than me, and she passed away.
And you have any other family members?
I do. I have 2 daughters, and I have 2 grandchildren.
Where do your daughters live?
I have a daughter in Middletown, and she's married, and I have a son-in-law, and she has 2 children, ages 2 and 5 months, and then I have another daughter who's in New York.
How did you first become interested in the law?
Probably watching Perry Mason on TV. You know, I grew up in the 50s and the 60s, and it was a time when there weren't very many women lawyers. So it wasn't like I knew women lawyers, but I had decided that law was something that could change the world, and so that's what I was going to do. Originally, I wanted to go into the Peace Corps. So throughout high school, I was going to join the Peace Corps, and then about junior year in college, that changed.
And speaking of high school, where did you grow up?
I grew up in Quincy, Massachusetts for the first 12 years, and then through high school, I grew up in a neighboring town, Braintree, Massachusetts.
And who were your role models as you were growing up?
There weren't really a lot of role models, I didn't think, when I was growing up, in terms of who I would go back and say, oh, this person was really a role model. There was an American history teacher probably in high school that I had as a role model, but there really weren't very many other role models.
What was your neighborhood like in Massachusetts as you were growing up?
For the first 12 years, we lived in a small apartment that I shared a bedroom with my sister, and it was a regular lower class, middle class city. Then we moved to Braintree. Now it's totally different. Both of those places are suburbs of Boston. At the time, they weren't.
And off you went to college. Where?
I went to Wheaton College. At that point in time, when I graduated from high school, a lot of the top colleges were only women's colleges. There really weren't co-ed colleges. And so I ended up going to Wheaton College in Norton, Massachusetts.
You didn't go too far out of your state.
I didn't.
And how did you choose Wheaton?
At that point in time, it was one of the considered one of the better women's colleges, and that's why I chose it. It had a strong government department, which is what I was interested in. That's what I majored in.
And what years did you go through college, and what was going on campus during those years?
That was an amazing time to go to college. I started college in '66 and finished college in '70. So I was in college during the height of the 60s. It was an amazing time to go to college. I was pretty heavily involved in what was going on during that period of time. My roommate's father was one of the ministers down in New Haven. We were heavily involved in going to the demonstrations in New Haven. During my last year of college, I ran one of the the strike committees. We struck on our last year of college, so we actually didn't need to complete exams.
That was a raging period of time, and I was in college during that period. Were you involved in the anti-war movement? The feminist movement was just beginning to start, the student protest movement on campus?
Well, it was the time also when Martin Luther King got killed, when Bobby Kennedy got killed. I was involved during my college years. I worked at Cambridge Legal Services. So I would commute from the college to Cambridge to work in a legal services office. During the summer before my senior year, I worked at Office of Economic Opportunity, OEO, who, believe it or not, you probably would never guess who the head of OEO was back in 1969. It was Donald Rumsfeld.
Yes.
So it was. So I was pretty heavily involved in all of the civil rights, the women's movement, the anti-war movement. A lot of us were involved in that period of time. There weren't a lot of women going to law school. My class was probably the first class that had, I think, 10 of us went to law school that year.
Where did you go to law school?
I went to Georgetown Law School in Washington, D.C. When I got to law school, I went from basically an all-women's college to an almost all-male law school. My father, having gone to law school, was not encouraging for me to go. He thought I would get swallowed up as a woman attorney trying to go to law school, so I proved him wrong.
And you went to law school in 1969-70?
I went 1970 to 73.
In Washington, D.C.?
I did.
And how did you choose Georgetown?
It was the best law school I got into. I wanted to be in the middle of what was going on. It gave you a lot of opportunities to work, see Congress, see the U.S. Supreme Court, and I took advantage of that.
Did you enjoy law school?
I did, yeah. I was pretty heavily involved in criminal defense at that time, and because all the anti-war protests were going on, we would be marshals at a lot of the demonstrations. We would represent, as part of the student clinics, some of the kids that got arrested. The person who was my boyfriend at the time was also a law student, and he had a job chauffeuring Justice Douglas to work every day. So I would hear stories, and then my very last day of law school, I got to go to Justice Douglas's house and pick him up and drive him to work that last morning and meet Justice Douglas. The other thing that was going on in 1973 when I graduated from law school was Roe versus Wade was being decided. And so when my boyfriend was not driving Justice Douglas, he was driving Justice Blackmun. And Justice Blackmun at the time was receiving a lot of death threats as a result of his work and decisions in Roe versus Wade. So there was a lot of activity at the court, and we as law students were constantly going to the oral arguments at the Supreme Court during this time period. So it was an exciting time to go to law school.
Justice William O. Douglas was perhaps the most liberal justice in the last 50 to 60 years. How did you look at his judicial philosophy?
He was probably, talk about role models, you know, he was somebody that I thought was one of the best justices that's been on the court. His voice has not been there since, and nobody's really replaced him.
Do you like camping like he used to take off for the summer term and hike up to high mountains in Washington without any telephone and communications? If someone had a special writ, they'd have to climb up there and give it to him.
It used to happen for him, yeah.
And what was the role of women in law school at the time you went there?
My class had, I think, approximately 300 students, and there were 30 women. And
did you have any interaction with your male law professors?
We did. The first year of law school, this was before they built the new nice building at Georgetown. We were in a sort of a crummy rundown building on 5th Street, And I remember one of the male law professors calling all the women in and being actually very patronizing to all of us because we were a phenomenon in the law school. The other thing that used to happen is they would call on students, the law professors, and if you were a male law student, you could duck because the professors didn't know who you were. But with the female law students, every time one of us got called on, everybody would turn around and look at us because they knew who we were, and so we couldn't pretend that we weren't there, we hadn't done the reading.
And do you recall about how many women were in your graduate class in relationship to the total number of men?
It was pretty much the same. I mean, most of the students at Georgetown, the graduation rate was pretty high.
But I mean, what was the ratio of the number of women to the number of men?
Probably 30 to 300, something like that.
And what do you remember most from law school?
The most I remember the work that I did, it really formed my thinking in terms of wanting to do legal work on behalf of those who could not afford to do legal work. And so I did the criminal clinic when I was in law school. We had a professor named Bill Greenhall who is pretty much a guru in the criminal defense world. And he instilled in us certain values that I try to instill in my students today.
Did you have any women law professors?
I recall one woman law professor, and that was Judy Arene, who went on to be the dean of the Georgetown Law School.
And now?
First year of teaching, and she was such a neophyte.
And now you're getting out of law school, and where are you looking to take the bar examination?
I actually applied to 2 jobs. When I got out of law school, I applied to a job at PDS, which was the Public Defender Service in DC, and I applied to the ACLU in Connecticut. And I got job offers from both and decided to, the first job out of law school was UConn Law School, the legal clinic at UConn Law School.
What year was that?
This was 1973, 74. And so I went and took the UConn legal clinic job.
And did you take any bar other than Connecticut?
No.
What was your experience like taking the bar?
It was difficult. Yeah, it was difficult.
Did you come to Connecticut, study in Washington, or go back home to Massachusetts and study?
Studied in Connecticut.
And
then I worked for the legal clinic for 2 years, did criminal defense work, and then went back to Georgetown to do the Brittain program, which is a graduate program in doing criminal defense and juvenile justice work. And so I did that for 2 years before I came back to Connecticut.
The Brittain program is still a very prestigious post-law school graduate program to train largely criminal defense lawyers. So you were in way back in the 1970s.
I was, yeah. We got instilled in us certain ethical values, work ethic, outlook that I think the people and the lawyers who went through that program, it has really influenced us all for our legal careers.
Were there any other women in the program with you?
There were. I mean, I think the program tried to bend over backwards at that point in time to try to equalize the applications and the appointments.
Now you're through high school, through college, through law school, took the Connecticut bar. You're back up here. Had any women lawyers come into your influence yet?
Probably at that point in time, there were very few women lawyers practicing. Probably Katie Rohrback was the main attorney that I used to look up to as a mentor. I think I first met Katie the very first time I came to Connecticut doing criminal defense work. It was not easy doing criminal defense work as a woman lawyer back then because the male judges and the court personnel were not used to having women lawyers in the courtroom. So I remember being in Center Courtroom on 95 Washington Street and needing to go down and talk to my client who was in the lockup. downstairs, and they would not let me down into the lockup as a woman attorney. They thought that it wasn't safe for me to be down there. So I had to argue with them and try to get the chief court judge to let me go down there, and then they wanted to put extra court personnel down there to let me go down there. It was sort of an anomaly to see women attorneys in the criminal court. You know, I think frankly, the number of women attorneys even today in the court has not increased so substantially, even after all of these years later. When I practiced law after that point in time, I'd go to short calendar, and it would be predominantly 95% male lawyers, and there'd be a few scattering of women attorneys in the court.
You mentioned Katie Rohrbach as a native nutmegger myself, and Katie was most of her life too. What was Katie's influence on you earlier, and what do you think was her legacy that at least impressed you the most?
I think early on, I think she had amazing courage to speak out. I had a lot of dealings with Katie when I came back to Connecticut and was the legal director of the ACLU. And Katie was on the board, and Katie and I did the Medicaid abortion cases together. So I believe it was 1979, we went into federal court together, and she was really my mentor because she had done the case of Women versus Connecticut, which was the early abortion case, and obviously everybody knows was involved with Griswold and those cases. And so when I came to Connecticut and was the legal director in '77, 2 years later, we went into federal court and did a case called Women's Health Services versus Marr. And Judge Blumenfeld was the judge at that point in time, very well-revered senior judge. And he granted us an injunction, and we won the case in federal court. At one point in time, Judge Blumenfeld was so sick that we actually had us all to his house to argue the case. And then the U.S. Supreme Court came down with couple of decisions, and basically you could no longer get protection for poor women for medically necessary abortions in federal court, so we had to go to state court. And then we went, but there is a Katie story that I think is really important to tell at this point in time, because we appealed to the Second Circuit Court of Appeals when because Judge Blumenfeld had to rule against us the second time. And we appealed to the Second Circuit Court of Appeals, and Judge Meskel was on the panel. And he had been governor of Connecticut, and he had a lot of anti-abortion statements. So Katie said to me at one point in time when we were planning the appeal, she said, "Martha, go over to the state library and pull out all of the newspaper articles and get every single statement that Judge Meskel had stated publicly that he was against abortion." So I said, "Katie, we can't do this, you know. I mean, we're going to challenge some judge on the Second Circuit Court of Appeals." I said, "I've never done this before. I can't do this." And Katie said, "You're going to do this, and this is what's needed for the women of Connecticut, and so I want you to go do this, and we're going to make a motion in the Second Circuit Court of Appeals to recuse Judge Meskel." And I said, "Okay, Katie, we'll do this." And so I went and we filed I filed a motion to recuse Judge Meskel. I appended all of his anti-abortion statements, and he did recuse himself. But I tell this story because this is what Katie left. This was the legacy that Katie left for me. It was that you have to have the courage of your convictions, to do something in the face of something that was very difficult, that no other attorneys would dare to do. But if you really believe in the law and the power of the law, to be able to make a difference for your clients, you put the clients first, you put your ego second, and you do what's needed to be done.
Describe, if you can recall, what was your first case?
The first case I had was in law school in the criminal clinic. I had a case where I represented an individual who had thrown a gun out the window, and then he was charged with possession. It was my first jury trial, which I actually won as a law student. And I remember going into the ladies' room and being nice to all the women jurors, and then I ended up winning the case.
Describe what you were thinking at that time in terms of your career. Did you have any idea then that you would be doing what you do now? We'll get to now a little later on. What were your aims the first 3 or 4 years out of law school?
First 4 years, I wanted to be a criminal defense attorney. That was my aim. During one of the years, my second year out of law school, I did a case called Brittain versus Manson. It was a habeas case that I filed on grand jury discrimination. And again, it was a Judge Blumenfeld case, and he ruled in our favor and then appealed to the Second Circuit. And we won in the Second Circuit. There was also a case that I did with a fellow attorney that was working with me named David Golub. And we had an identification case called Brathwaite versus Manson, and it actually went to the U.S. Supreme Court. And neither one of us had been a lawyer for 3 years at that point in time. So they had to hold up the briefs at the U.S. Supreme Court so that we'd reach the 3-year mark so that they could stamp the briefs in so that we could participate in the case before the U.S. Supreme Court.
So in other words, they had to hold it up until you had the minimum number of years in order to become licensed to practice in the Supreme Court.
Yeah.
Very interesting. Of course, David Golub is still practicing
He
today
is
too
very
in Connecticut.
well known, very excellent, one of the best lawyers I've ever worked with.
Now, during this period, did you notice any difference between men and women attorneys in practice, other than the story you told about not being able to go down to the jail at first? And
I remember when I would go in for a continuance, the judges gave me a hard time. I remember one particular judge just screaming at me. I do not think that would have happened if I had not been a woman attorney. I think I was not, there weren't any other people, who were doing this work.
And was there any other kind of Katie Rohrbach around during that time, at least that you knew of?
Yeah, there really weren't. I mean, the other women that were doing some good work was Kathy Emmett at the time and Bev Hodgson. They were both at Koskoff and Beater. I think their role model was Ted Koskoff. So there was a community of lawyers. We all knew each other. But other than them, I don't think there were lawyers that were out there doing this work.
Do you recall any instances in which clients seemingly viewed you somewhat differently as a woman when you were representing them?
I really don't. I don't think that the discrimination or the differential treatment came from the clients. I think the clients were much more accepting than the court personnel and the judges.
Let me go back to your family for a minute. How old are your daughters now?
I have one daughter who's 27 and another daughter who's 29.
You have any grandchildren?
I have 2 grandchildren aged 2 and 5 months.
How do you think being a mother and a lawyer affected your career?
Well, I think in a few ways. First of all, it was having grown up in the 60s, we thought we could do it all. So I was a working parent. I was trying to do a high-pressured, high-powered job. I was raising my 2 children. I was chair of the school board. I was on the Connecticut Law Tribune board. I had some other boards. And I think that myself and some others of my colleagues, we thought we could do everything. And I think it was on the one hand, very difficult. And I do tell my young women lawyers, don't do what I did. But on the other hand, I look at my 2 children and I felt like it was very important for me to show my children the work that I did. So my children went to pro-abortion rallies. My children went to, when I was doing West versus Manson, which was the prison case down at Niantic, my kids sat in the parking lot while I was inside The prison, I would bring their toys, their leftover toys when they didn't use them anymore. I would bring them to the nursery at Niantic Prison. I think you know the story, John, of the first day of the chef trial. I took my two little kids out of, I think they were in first and third grade, and I brought them to the front row of our chef trial, and I sat them and I said, you have to witness history here. And so if I look at them now, like what are they doing now? My one daughter is a social worker. My son-in-law runs a mentoring program for foster kids. And my other daughter is a director of special ed for one of the urban charter schools, and she's really involved in the urban education. So something rubbed off on my children. They probably paid a price for it.
Mm-hmm. Did they have any kind of family medical leave back there when you became pregnant?
I took 2 months off from work, both times. I guess actually I took 3 months off, and so the first time when I came back, I did the Medicaid abortion case with Shelley Jabal in state court at that point in time. I did another case, I remember I was about 9 months pregnant before Judge Burns in federal court. She kept wanting me to sit down. And then the other time when I was pregnant, we were doing the West Farms Mall case, and they were bringing affidavits to me in the hospital to sign after I delivered my second child.
What was that West Farms Mall case? Was that First Amendment?
First Amendment.
Access to
speech.
demonstrate?
Yeah, free speech.
On private property, so-called?
Which we claimed West Farms Mall wasn't really private property.
Mm-hmm. Now, at some point, I recall being your colleague, that you went on to become the legal director of the Connecticut ACLU. Tell me about that experience.
Well, I said I would come back to Connecticut for one job because I did not have any ties, really, of family ties or anything to Connecticut. And I applied for the ACLU job. I remember being interviewed by Tom Emerson. He was the legal advisor at that point in time. I had tremendous respect for Tom. Manny Margolis was involved. Katie was involved. And I got the job. And I was 28 years old. And I came back and was legal director of the ACLU at that point in time. And thereafter, we did some, you know, sort of, we had no fear, I guess, is what I would say. Two things. I would say we had no fear, and the climate of the federal courts was a lot different than it is now.
Tom Emerson, of course, the well-known distinguished law professor from Yale University, and Manny Margolis from the University of Bridgeport over to Quinnipiac Law School. Had there been a woman legal director of the ACLU before you?
There'd only been one other legal director, which was Frank Cochran, so I was the second.
And Bill O's was the executive director during those days.
Yeah.
And you set out on a number of pathways as a legal director for the ACLU of Connecticut. What were some of your most distinguished cases during that period?
The first couple of years, I did a lot of prison litigation. One case was West versus Manson. It was a case where they were strip searching women who were coming into the prison. I remember we hand-picked one of the plaintiffs. She was a nun who had protested an electric boat, and we used her as a plaintiff. So we improved the conditions, and the other thing I remember about that case was the women, they put the women in what they called the dungeon, women with mental health problems, and they put football helmets on them, and they would just let the women be in the dungeon and bang their heads against the wall. And so we brought a conditions case and got a consent decree and improved conditions. That was one case we did. Then we did the Medicaid abortion cases, which I think was pretty significant.
Now let me stop you right there. You keep using that term, Medicaid abortion. What was the issue in that case?
The issue was that women poor women who needed medically necessary abortions could not get them because the federal government had come out with some restrictions on using federal funding for medically necessary abortions. And these were women who really had no means. The abortions were necessary to protect their health. and they did not have access to reproductive health care that they needed. And so we went into federal court the first time that I explained, and then thereafter we went to Judge Brittain and got an injunction, which carries to this day. That injunction was never appealed. I believe that's one of the important legacies that Governor O'Neill left behind, which was he never appealed that injunction. And so the injunction, the permanent injunction that Shelley Jabal and I got for the poor women in Connecticut back in the early 80s still stands today.
And what does that injunction say?
It says basically that the state cannot deny poor women access to reproductive health care in order to protect their health. And the reproductive health care would include medically necessary abortions.
And in other words, the court said that reproductive health care is the same as any other medical condition?
Yes, yeah. And it would be a denial of constitutional rights, right to privacy and due process, to deny women access to health care that they needed.
You were quite involved, too, in juvenile delinquency facilities here and education for children in those facilities, weren't you?
One of the cases I brought was Emily J. versus Weicker. It was brought in 1993, settled in 1997, which involved education and conditions of confinement in the 3 juvenile detention facilities. We were able to get a consent decree improving medical and mental health and conditions in that case, and then I went back to court in that case in 2002 because the mental health of kids was still not being addressed, and kids were languishing in detention waiting for mental health services. And I remember I went back and filed a preliminary injunction before Judge Schotteny at that point in time, and I remember Judge Schotteny being tremendously moved by the testimony. I actually got a Superior Court judge to come into federal court and testify on my behalf, saying that the kids were being deprived of mental health services. Again, you asked me what the legacy that Katie left behind. It was basically the courage to subpoena a Superior Court judge to bring them into federal court and do this.
As a witness?
As a witness. And then we brought in testimony about the kids in juvenile detention crawling up in little balls, hiding underneath the detention beds. Because they were, their mental health had deteriorated so much. And so Judge Schotteny was tremendously moved by the testimony of the Superior Court judge and some other, these stories that we told. You know, one of the things that I learned from law school that I don't think people do enough today is tell the stories, get the voices of the kids, get the voices of the clients, tell the emotional aspects of the stories. Because you can't help but be moved by the stories. And when we get to talk about Chef, I guess we'll talk about those stories, John, that we shared together. So we were able to get an injunction from Judge Schotteny about improving the mental health conditions, and I was able to get 2 other consent decrees with the state in improving mental health for kids in the juvenile justice system.
And part of your work, and something unique to Connecticut and its Constitution, is a part of the court that's not judging cases actually runs facilities, correct? Some of those juvenile
They did. They ran facilities and then ran programs. So, yes.
So you were suing an agency which was a part of the judiciary.
Department, yeah, I was. One of the, a couple of other cases that I think are important to talk about. One of the cases was 2 other cases, big cases that I did that I want to get to. But one other case that wasn't mentioned yet is the AIDS case. We found that it was at the beginning of the AIDS epidemic in the late 80s, and New Haven had taken all of the kids who had HIV and AIDS, and they had put them in the basement of the Urban League building in New Haven. They had segregated them and removed them, they would not let them go to school, and had removed them from the school and put them in the basement in this one tiny little room in the basement of the building, the Urban League building. And we got as one of our witnesses, one of our experts, Al Solnit, who had ran Yale Child Study Center and had been Commissioner of Mental Health Services, and he came with us And we visited the classroom where the kids would have gone if they had been allowed to go to school, and we visited this, tiny little terrible room in the basement, and he was so appalled. And we basically ended up going to, that was brought against the city of New Haven. Once they found out that Al Solnit was going to be our main witness, they caved right away, and gave us a consent decree. And the little girl, who is the named plaintiff in that case, when she found out that she was going to be able to go to a real school, I'll never forget this story. She went and ran to the closet and got her patent leather shoes and put on her shoes and said, "I'm going to go to real school tomorrow." And she actually ended up passing away from AIDS. So it was a happy ending and a sad ending at the same time.
Now, Martha, do you think that being a female lawyer had any part in your pursuit on behalf of some of the most troubled children, some of the most disadvantaged persons in these legal cases?
I probably played in some part, yeah, because I was able to have my children have what these kids did not have. Shelley Jabal and I brought the main case against DCF that resulted in the large consent decree. And that was a lot of work, preparation. We filed that case in 1989. It was actually the same year that we filed Sheff versus O'Neill. So I spent the middle to late 80s getting ready for these two huge cases on behalf of kids that I think, it has made a difference, hopefully, for thousands of kids.
And like those two cases, they never seem to end. When they do end with a decision, do they?
Yeah, they don't. But one of the things that I tell students and I tell other lawyers, that if you really want to do civil rights work, you have to be in it for the long haul. Because the problems were immense before you started, and it's difficult in the remedies, and you have to just be dogged about the remedies as much as you were dogged about bringing the lawsuits to begin with. So there's a lot of consent judgments out there that still need compliance.
You are a member of the bar as a lawyer, but have you been active with the bar associations at all?
No, I wasn't active with the Connecticut Bar Association. I did hold different other positions. I was on the Connecticut Law Tribune Board. I did the Inns of Court as a mentor. Actually, Judge Shotney and I ran together one of the mentoring groups for that. And then during this period of time, I was also on my local Board of Education, and for 13 years, and I was chairperson of the board for 3 of those years.
And have you had any other outstanding community activities?
Those are probably the main community activities.
I don't see how you would have time for any more. Let's go into let's go into Sheff now.
Okay.
Is there one more before that one that I've missed?
Well, the Juan F. case, the consent judgment with DCF, I think when Shelley and I first were exploring that case, one of the things that we
Now, is this the foster care case?
This is the foster care case, yeah.
Tell us a little bit about foster care.
Well, in Connecticut at that point in time, the department was in total disarray. We had a training academy of the DCF, which was in the basement of a building on Sigourney Street. Workers carried caseloads of 60 to 70 cases. There were very few facilities, very few foster homes. Kids were really not well treated in the foster care system. And so when we were trying to get witnesses for the case, what we kept running into was people didn't want to talk because they didn't want to bite the hand that fed them. They were getting money from the state. And so part of our...
These are mainly foster parents?
These were, providers.
Providers, I should say, yes.
Yeah, so they were getting contracts with the state. They didn't want to speak up. The workers didn't want to speak up because they were employed by the state. And so our biggest challenge doing that case was what we called breaking the conspiracy of silence. It was really necessary to get people who were willing, again, to have the courage to stand up and break the conspiracy of silence. And so it took us about a year. And we did find plaintiffs who were professionals in the community. Nancy Humphreys, who was dean of the social work school, was willing to be a plaintiff even though the case was against the state and she was employed by the state. We had people from the Child Guidance Clinic. I have tremendous respect for the people who agreed to be plaintiffs in that lawsuit because they did have the courage to speak up.
Some of them were social workers, weren't they?
Some of them were social workers. They weren't. They were employed by private agencies. And then we had a lot of people from the inside of the agency who we would meet in coffee shops and in people's homes, and they would give us information and tell us off the record what was going on, and that's how we put that case together.
Now, who were these children in foster care? Where do foster care children come from?
Well, they come from all over. The majority of them come from the big urban cities, but you know, child abuse doesn't have is broken down with economics and doesn't have an economic floor.
But these are children who have been separated from their parents,
Right.
either because the state ended parental, terminated.
Or they filed neglect or abuse petitions, and all of these kids had been abused and neglected. So what we were finding at the time, kids would have 27 placements. It was not unusual to have 13 foster homes. It was, you know, and one of the things, the sort of takeaway that we would look at from the kids is the amazing resilience of these kids who had been through so much. So we filed the lawsuit in '89. We went into, Judge Nevis was the judge. We made a tactical decision to bring a temporary restraining order on behalf of one child right within 3 months of filing the lawsuit. We filed a TRO. The judge granted it. He was appalled by hearing the story, and he sent the case for settlement negotiations with Judge Zampano. And Judge Zampano then forged a settlement a year and a half later, and we got a huge consent decree that basically infused millions of dollars into the Department of Children and Families. When we filed the case, we were asked by, before we filed the case, we were asked by the state, would we agree to $10 million more if we didn't file the case? And we said no, that wasn't going to be enough. So we filed.
Do they call that chutzpah?
And now I think the budget of the Department of Children and Families, the budget would have been $90 million then. The budget now is $880 million. So there's been tremendous improvements in the system. There's still a ways to go. And now we get to Chef, John.
When did we first start looking at the educational segregation and the disadvantages in the system, as you recall?
Yes, I recall, and I want to just say that I am grateful that you're doing this interview of me because we've been colleagues for a long time, and I have tremendous respect for you as a person and as a lawyer and as a colleague. So thank you for doing this interview for me. Because we have amazing stories on Chef to tell, because we first started, I remember, I think it was, if we filed the case in '89, we started this effort in about '87, and we went and did a lot of interviews in the
Well, we had that false alarm first.
Yes.
Where we started back with the NAACP
Yes, and the
around
community
83, 84.
did not want to file this lawsuit, I remember, because there was a real strong interest in neighborhood schools. They didn't want any children bussed out of Hartford. I remember Boyd Hines and some other people who got us together and said, oh, we think you should do this lawsuit. And you and I were very clear that without community support, we were not going to do this lawsuit. At the same time, we were trying to figure out what the legal theory was. And there was a student at Yale Law School who I remember did a paper for us and for Don Pogue, and trying to figure out what a state constitutional legal theory would be. And looking at the state constitution, because we couldn't bring this case in federal court.
Now, you mentioned a lot of names in there. Don Pogue, of course, was one of the leading labor lawyers at the time, and often represented teachers' unions. You mentioned Boyd Hines was a very popular state representative from the north end of Hartford, who was a strong housing advocate. His wife, Wendy, was side by side with him. He was one of the most activists state legislators of his era. And you talked about how we were meeting and we were investigating. At one time, we were having these periodic discussions with Don Pogue, with Ben Andrews, who was the head of the NAACP, with your boss then, Bill O's of the ACLU, and just anybody who would listen, and whoever had anything to do with education in the state of Connecticut. Who was that longtime education chair of the legislature? She was very active with us during the time, telling us all the history. But in any event, we work ourselves up. So how did we come to file Sheff versus O'Neill in 1989?
Yeah, we came, I think what really made the community want to file Sheff versus O'Neill, I think Jerry Tarazzi was the commissioner at that point in time, and they had just instituted the mastery tests. And the mastery test scores were released, and Hartford was at the bottom of the bottom. And I think when people saw how the children in Hartford were getting deprived of an equal educational opportunity, and the outcomes were significantly, so drastically less than what was comparable in the surrounding communities, I think that that really was one of the main factors in people really, an outcry saying, no, this is not right, this is unequal. You know, ACLU, Martha, John Brittain, UConn Law School professor, what can you do about this? So that was when we got together a legal team, and we went to the NAACP Legal Defense Fund. At that point in time, we went to the Puerto Rican Legal Defense Fund, and we went to Wesley Horton as a private attorney who had done some state constitutional work. He had done Horton versus Meskel, and we brought together the legal team, and we were the legal team for most of the lawsuit.
Now, we had a big legal team. We had the NAACP Legal Defense Fund from New York, the organization of Thurgood Marshall and Brown versus Board of Education. Staying in New York, we had the National ACLU, and we had the Puerto Rican Legal Defense and Education Fund. Three major organizations out of New York, and then coming up here in Connecticut, we picked up, along with the National ACLU, the Connecticut ACLU, where you were the legal director, and we had the Neighborhood Legal Services and their Farm Workers Project with Wilfredo Rodriguez. Yeah. And then, as you say, we had Wes Horton and yours truly.
And we had my colleague Phil Tegler, too.
And Phil Tegler, yes, and many persons from all those other organizations over years. Sometimes lawyers got married, sometimes lawyers had babies.
We watched them grow up, right?
That's right. And we had one distinction, is that we never had a disagreement that would have triggered our decision-making contract in which we would vote by majority vote.
Yeah. I think that agreement that you're alluding to was really bespeaks to how well the legal team worked together throughout the years that we were together on this case. We never ever disagreed, had a disagreement that we needed to vote. But when we first started getting together this case, John, I remember you and I, we would go, Hernan LaFontaine was the superintendent at that point in time, and he was very welcoming to us. And he opened up the doors of the Board of Education basically and said, what do you need? And you and I, we would go very many times to that Board of Education building, and they had a red door, and they had a crumbling red door. And every time we went in and out of that red door, we would say to ourselves, this is the reason that the school system is in such disarray that they can't even paint the red door. Yeah. And we said, when we win this case, you and I are going to come back with a paintbrush and paint that red door. But some of my fondest memories of working together on this case is when we had to decide who the principals would be. And I think there were something like 20-something principals in Hartford at the time, and we wanted to make sure that we had the best principals for the testimony. So you and I, we would just drive around and we would go and interview all of these principals to get the best stories and the best principals. And then we put the case together with a combination of principals and teachers and other people in the community, and did the lawsuit, did the trial in Superior Court.
Speaking of
in
your
West
stories, tell us the Gloria Hernandez story,
Gloria
the
Hernandez
elementary
story,
school
yeah.
teacher.
Well, she was one of the first witnesses at the trial. She was the witness that I had brought my kids into the courtroom to hear, and she was a teacher in the school system. She was teaching first grade, and she told us the story at trial of how she brought her kids on a field trip, and they went over the Connecticut River. I think they were going to East Hartford or someplace, and the kids had never been outside of their neighborhood. And so when they got on the bus and they crossed the Connecticut River, they all stood up and gave the river a standing ovation. And I think that story and the other stories that we told at the trial about the one school classroom where the pigeons were flying into the classroom, that the conditions were so decrepit that how could the kids learn when the pigeons are flying around in the classroom, or the story about the teacher who told, I think it was the Weaver High or Hartford High Library, where if every child took one book home, there would be no more books in the library. We tried to do the case through the stories of what it was like for these kids to be having unequal educational opportunities.
And yet they were surrounded by such affluent and high-performing school district. And there was a Project Concern, a program, where going back to 1965, some students could transfer from Hartford to the suburban districts. Not many, but some.
And so part of the trial was to show the disparities, and so we would bring in superintendents from outside Hartford to show how within a few miles of Hartford the disparities were stark, and the disparities were unacceptable, and the disparities were frankly unconstitutional.
Speaking of disparities, I remember we couldn't figure out how do you show disparities in education. And we looked up and found an expert out of Columbia Teachers College in New York, Gary Natriello. And he always taught me that you look at the community where the children in the family live in terms of their economic status, in terms of the crime rate, in terms of the adequacy or inadequacy of the housing, in terms of drugs, in terms of unemployment, in terms of other health conditions. And you look at where the children are coming from, and then when you go into the school, you look at what disadvantages they bring in terms of lack of a meal, lack of a parent at home to help them, a lack of developmental assistance in their learning disabilities. And then you look at the outcome, which is what we measured by the achievement rate on those standard tests, the graduation rate, the college readiness rate, the language, science achievement rates. And those were the disparities that were so stark between Hartford and its surrounding communities. How did you process all of that information, Martha?
Well, we had a team, John. We worked pretty hard, as you remember, with all our witnesses. I can't remember how many witnesses we had. I think you, me, and Phil Tegler did most of the direct examination of all the witnesses. And it was pretty compelling.
And the rest is history in terms of its conclusion. Now, when I sit and recollect, Martha, your role with the children in the deplorable delinquency conditions, the poor children in the Haven who had AIDS were shunted into a virtual dungeon. When I look at the children in the foster care system, the mothers who were not receiving medical services for reproductive rights, and then the thousands of poor and children of color in Hartford who are receiving an unequal educational opportunity, how do you maintain your focus on those cases, yet go home and relax and interact with your family?
Well, I tell people that I don't have good boundaries. So, you know, when you say, how do you do all this work and then you go home and relax, you know, frankly, if you're a really good lawyer, you don't go home and relax because it's an, you know, 5:30, 5 o'clock, it's not an artificial boundary. And I think that if I were to go home and segregate out my emotional from the work, I would not be able to do as good a job as I try to do and be as passionate. And in fact, you know, you're not supposed to take your clients home. And when I was doing one of the cases, I ended up being a mentor to one of the girls who was at Long Lane School, and she then went to a residential, and I was still her mentor, and then it was time to have her go to foster care, and they came to me and they said, would you take her home? And at that point I had my, you know, my 2 own children, and I said, no, I can't take her home. And I said I would do respite for her. So I did respite for her, and then her own foster home disappeared, and that's how I ended up being a foster parent for her. So is there a line between the work and your personal life? Not really.
What do you enjoy doing when you're not working on these cases? Do you still garden?
No, I didn't. I was not a big gardener.
You didn't have any green thumb?
No, no. I like to do a lot of bike riding. I like to go sailing. I like to do hiking. I like to do outside activities. I like to do things with my kids.
So you've had quite a career so far, Martha, and as the saying goes, I'm sure you're just beginning, and you have much further to go. What do you think has been your most significant contribution as a lawyer, particularly as a woman lawyer?
It's hard to say what's the most significant. I mean, we haven't talked about what I'm doing now either.
Yes, I'm getting to that.
You know, it's a combination of the big cases that I have brought in the past, and the office, the Center for Children's Advocacy that I created back in '97.
We left off with you founding the Center for Children's Advocacy in 1997. How did that come about?
After I left the ACLU, I went to work for Children's Rights in New York. It was a national foster care litigation nonprofit, and we were doing cases all over the country, and I was still living in Connecticut trying to do that work, and I realized I really couldn't do that and still have my children at home, and there was still so much to be done left in Connecticut. So I went to you, and I went to Kathy Emmett, and I asked you if you would help me incorporate the Center for Children's Advocacy, because I had a vision of exactly what I wanted to do with the children's organization, having done all these children's cases. I wanted a one-stop shopping place for children, where you wouldn't go and you say, well, I don't do that kind of legal work. I don't do legislation. I don't do policy advocacy. I wanted to have a place where, on behalf of poor children, you would have a place that you would do all kinds of advocacy on all kinds of issues. So you two were gracious to agree to incorporate, and we incorporated. And I went to Hugh McGill, who was dean of the law school, UConn Law School at that time, and I said, Hugh, I have this idea with John and Kathy to create this nonprofit. Will you help me? And he gave me $2,000, a room over the boiler at the law school, gave me a computer, and he said, I have no more money, and you can do this if you want. So I said, fine, I'll take it. So I took the $2,000. We incorporated the organization, and George Shotsky at the time was head of the Connecticut Bar Foundation. So you helped me open up the doors with George, the Connecticut Bar Foundation, they gave us a $9,000 planning grant. So now I had $11,000, not enough to pay the salary or the health insurance for my children, but we were at a start, and I guess the rest is history.
15 years ago, and you're still going.
Yeah.
And you have your own facility outside of the law school. And what do you see today as the critical issues facing children and equality?
Some of the issues, unfortunately, are still the same that I saw years ago when I started the organization. The educational disparity issue is still pretty significant. I mean, in Chef, we made a difference for, a huge percentage of the Hartford population of kids, but there are thousands of kids that are left behind in schools that are not performing. And the students are not learning. And I would say the same thing about Bridgeport. I think Bridgeport now has one of the poorest performing school systems in Connecticut. It's really almost displaced Hartford. And equal educational opportunity is not there for the kids. I think that still is one of the most burning issues. There's a lot of other issues that I see still going on.
What have been some of your professional experiences in dealing with race and inequality in Connecticut, other than in education and Chef?
Well, I did the Men and Women for Justice case back when I was legal director of the ACLU.
Who were the Men and Women for Justice?
Men and Women for Justice was an organization of Black and Latino state police officers. And they had been discriminated against in hiring, in promotions, within the department. And actually, one of the people that was the leader of Men and Women for Justice at the time, I brought the lawsuit with David Rosen, attorney David Rosen from New Haven. We brought an employment discrimination case against the Connecticut State Police. One of our main people that we worked with was Reuben Bradford, who at that point I believe was just a trooper. And now, as we sit here today in 2012, Reuben Bradford is the commissioner of the state police. And so back then, he was in the forefront of really forging ahead for discriminatory treatment on behalf of Black and Latino officers. I did a similar case for the Waterbury Police Department. It was a race discrimination case against the Waterbury Police Department, and Judge Zampiano really helped us in both of those cases. But we got consent decrees, and we were constantly going back to Judge Zampiano because of the kind of treatment and harassment that used to happen to the minority police officers, with half-eaten chocolate donuts put in their lockers and just terrible treatment. We had to keep constantly going back for violations of the consent decree. Now I'm involved in a really interesting project on disproportionate minority contact, what we call DMC, in the juvenile justice system. Because there is still discriminatory treatment on behalf of kids of color in the juvenile justice system, and we have tremendous efforts going on in Bridgeport and Hartford around those two issues.
If you had a chance to live your life over again, would you have become an attorney?
Yes.
The same attorney you are now, or could you see a different form of an attorney?
Probably the same as I'm doing now. I mean, what's interesting now is I do the individual and the systemic work. But for so much of my life, I only did the systemic work, and I think I'm better at designing what the remedies are now, sort of seeing life at the bottom for the kids and then being able to change the system issues at the top.
What advice would you give to a woman entering the legal profession today?
I would basically say that I would give the advice that you have to prepare your law school resume to what you want to do when you graduate, because the opportunities are not nearly out there as much as they were before. And if you want to be a public interest lawyer, woman lawyer, then you better get your resume packed with public interest opportunities and internships and clinics while you're in law school. What I would say to women lawyers who are parents, I would say don't do what I did. which was I was a parent and I had a job, and then I did too many extracurricular things.
Interesting. Has your role in the practice of law changed at all over the years?
I do less federal civil rights litigation than I did. I would like to change that back, and I wish I could do more. It's a lot harder now to do federal civil rights litigation because of the climate of the U.S. Supreme Court. I mean, you and I, we've watched it just get so conservative and put up so many barriers that it's very difficult now to do federal civil rights litigation.
What do you think has been the role of technology in the law? And if any particular reference to the kind of work you do in public interest?
There's been some in terms of, you can do filings by a press of a button. You can get easier access to court pleadings now. When I was first practicing law, there was carbon paper and whiteout. So the fact that there's computers now is obviously a huge. You can get so much more legal research done. You can find sources now. It's really enhanced the practice.
What do you think is the state of public interest practice today? And what challenges do you face in running a public interest organization, both engaged in public policy as well as in litigation?
Well, running a nonprofit legal services type of organization, we have tremendous challenges funding-wise. As you know, the IOLTA money has almost dried up or substantially gone down. All of us are facing tremendous challenges to keep the staff that we have, keep the salaries competitive, and triage the work. There's too much work for the little number of attorneys doing this work. And I don't think that the private bar has stepped up and helped.
What do you think is the role of the private bar in relation to nonprofit, public interest, legal organizations?
Well, I believe in mandatory pro bono, which Connecticut does not have. I believe that the major law firms in Connecticut have not played a significant part in helping the poor, and I think they need to do a lot more. Our experience with private law firms in all of my years of practice, whether it was at the ACLU or running the Center for Children's Advocacy, has been disappointing. When law firms agree to take on cases, they delegate it to their least senior person, and by the time you're finished, you've got a first-year associate who basically sometimes in our experience has dumped the case back on us at the last minute. So it's been extremely disappointing.
What do you think are the advantages, rewards that you gain from your career?
I say to the law students that I teach now that I have had every single legal job that I've had, I have never woken up and not wanted to go to work. And I don't think there are very many lawyers that can say that. So I feel privileged to have been able to do the kind of work that I've done over the years and to be able to help thousands of people. And
I will come back to a question you kind of shied away from, but what do you think has been the accomplishment of your life that you're the most proud of?
Apart from my family, which I'm tremendously proud of my children and my grandchildren, I would say Sheff versus O'Neill, the foster care litigation, the Medicaid abortion case, the Emily J. juvenile detention case, and the creation of the Center for Children's Advocacy, where now we have 8 attorneys out there all over the state doing work for poor children.
Do you think that the needs of poor children have changed any over the past 30 years that you've been involved?
No. I mean, some have gotten better, some have gotten worse, but there's still issues. to be addressed. There's been some improvements in health care access for poor children. I think there has been some improvements in that field. Mental health access has not improved. Education has not improved enough. Opportunities, housing opportunities, income is still some of the same issues. Poverty in Connecticut is still significant.
What do you think is the allocation of time between engaging in litigation versus engaging in public policy advocacy, both before any legislative or any administrative bodies to change rules, or just advocating for a broader community support for a certain policy?
For me now, or just in general?
Both for you as well as in general.
Well, for me now, we're putting a lot more emphasis into policy advocacy and legislative. We've been able to write bills and get them passed in the Connecticut legislature. And we're turning to other bodies, the executive and the legislature, because of the court system and because the federal courts are not really a friendly climate anymore to bring some of these large class action kind of cases. So we've had to do more policy advocacy. And in some ways, one of the advantages I guess I have of having done this work for as long as I have, that you get a reputation for yourself, for better or for worse. So sometimes we can resolve things pretty easily by just calling up somebody and saying, "Oh, we have the power of being an attorney behind us, and we can get things resolved really quickly for kids now."
Is that a form of maturity and sophistication as an organization, as a strategy?
Yeah, I think it's both that. It's both, Martha Stone is on the other end of the line, and if you don't do this, she's going to bring her 7 other attorneys, and they're going to go litigate this issue. And by the way, she's had some success in the past, so it is the reputation that you get. And in Connecticut, everybody knows everybody else. So for better or for worse, you get a reputation. You're able to do things or not do things based on that. And we've matured over the years in terms of the tactics and how we do the cases and the issues.
But children's advocacy still remains uppermost in your advocacy, is that right?
Yeah, civil rights, children's advocacy, I don't distinguish between the two.
And what has led you to focus on children as opposed to adults in voting, adults in housing, better criminal representation, particularly for adults? What is it that attracts you to help children?
I think it's a combination of both. Having done criminal defense work where I mostly represented adults, and I would watch them cycle in and out of the system. So I would get people out of jail, and then they would 6 months later get rearrested. And I never really felt like I made a difference in the systems that would have prevented them. So in some ways it's a prevention model to me. It's a prevention strategy to deal with kids, because if you get them early, it potentially can prevent the parents who are abusing and neglecting their kids, or some of the other issues that I dealt with for the adults.
Have you played any role in supporting particularly women to become judges?
In the federal system, I would get calls. That there used to be committees. I think it was out of the Permanent Commission for the Status of Women. They would call and they would say, who would you recommend to be interviewed for a judge? And that was actually true for the state court system. So I would put forward some names of women that are actually some people who are judges now, and unfortunately people like Bev Hodgson and Kathy Emmett, who got out of the judicial profession.
Why have you not become a judge?
Well, it's presumptuous to think that I could become a judge, but I've never actually applied to be a judge, because I feel, and I would surmise that it's probably in some ways the same reason you've never applied for a judge. When you're an advocate to your core and you see injustice at your core, you can't be impartial. You have to be outspoken for the people that need to be a voice for, and to take myself out of that role and put me in a courtroom where I would have to pretend to be neutral, where I would have to send people to jail for years and years, and until yesterday would have to impose the death penalty, which I totally don't believe in. I would never want to be a judge. Is that the same reason for you, John?
Yes, it is.
Yeah. I think that from one advocate to another, you can understand the passion that we bring to an advocate's role, and if you are a really true advocate, it would be hard to take you out of that position.
I enjoy helping good people to become judges, and consider that a part of my public policy advocacy, to make the bench representative in many diverse ways, not only racially, economically, ethnically, but from workplace experiences and from life experiences. Now, Martha, as you look forward, do you think you'll be doing this for as long as you're able? Like we know some lawyers up in senior years that are still practicing?
Well,
Or do you see yourself retiring at some point?
Yeah. That's a rhetorical question, John. I mean, my father worked till he was 88, and he lived to be 90, and my mother is 91. So I have too much work left to do, and too many injustices to address, and so no, I'm not really interested in retiring. I think there's a lot more to do. And I'm interested in looking at Bridgeport and looking at the injustices that kids in the educational system are facing there. And I think that's a really important lawsuit to be brought. So I would welcome partnering with you and others on such an important adventure.
As you look back, you mentioned, of course, Shelley, you mentioned Bev, you mentioned a number of women. When you look back now, or if you were to go out and speak to a high school class tomorrow, who would you point to as some role model of judges that you've seen in Connecticut or beyond who are women?
That I would consider significant role models. I mean, I have mentioned Bev and I have mentioned Kathy Emmett. They're two that I would, in terms of judges, that I would consider on the on the U.S. Supreme Court. There's Ruth Ginsburg. There's Sonia Sotomayor. The newer judges on the U.S. Supreme Court. There aren't a lot of judges that, unfortunately, that I could say, oh yeah, look at these role models. I would also point to Nancy Gertner, who was the U.S. District Judge in Boston, who I would say is a good role model for women attorneys.
And how about non-judges, just lawyers? Who would you look back on and refer to some high school students today that are good women role models that you have high regard for?
Well, Katie was probably one of the most leading women attorneys that I would look to. One of the smartest lawyers I've worked with is Shelley Jabal, who is an attorney who we did these cases together. I don't have a laundry list of women attorneys that I would list.
Well, Martha, is there anything else you would like to say in this interview?
I don't think so, John. I think you've kind of covered my legal career.
But we definitely want to talk about Sheff versus O'Neill one day.
Yeah, I think we have a lot of stories to tell about that case. And all I can say in his closing, I really, as I said somewhere in the middle of this interview, I really appreciated you coming here to do this interview. I know it was an imposition on you, and it bespeaks to our friendship, so thank you.
I couldn't think of a better person to come and talk with you. We don't have a chance to talk enough, but when we do get together, It's always warm and wonderful.
Yeah. Well, I want to flip this and interview you the next time.
All right. Well, thank you very much.
Okay.
And this ends the interview with Martha Stone.